Hi, this is Heather Orr with Bootleg Legal. This lesson is going to be on how to avoid litigation, how to keep yourself out of the courtroom. My background in this area is that I litigated for 10 years and I've done transactional work for 10 years. 5 of those years overlapped, which gives me sort of special insight into how to use the transactional legal world to help protect yourself from litigation and to minimize your expense and risk in the event that you find yourself in litigation. I've seen several trends throughout the years when, at one point I had litigated and won 6 cases in a row, but no one ever felt like they were winning, right? Because they spent 2 years in litigation, both parties just slinging mud the entire time. They paid way too much money to me. It was exhausting. The mental load was intense. It stopped them from working on other aspects of their business. And they ended up, at the end, even when they won, they felt like they lost. Litigation is a losing prospect most of the time. Please ignore my dog. When I realized this, I started to look for trends. Like, well, why are most of these clients ending up in litigation to begin with? And I started taking notes and I started assessing cases in that light. And then I started telling businesses, like, these tend to be the things that end you up in the hot seat. So I'm going to give you the shortcuts. Number 1, and if you've watched this whole course, you've probably already watched the contract section, but number 1 is to memorialize agreements in writing. When you do business on a handshake, you're basically inviting a dispute in. Parties may not understand each other. They may have very different understandings of what the contract was supposed to be. Or one of them may just be opportunistic and say, well, we didn't put that in writing. I'm not going to do it, even if they do recall agreeing to it. Whether or not you draft a formal agreement, or whether or not you have an attorney even help you draft that formal agreement, or you just reduce your agreement to an email summary of what your phone call was. Any of these things are better than not having them, right? Obviously, they vary and they're how good that they are, but they're all better than nothing. So, memorialize agreements in writing. Number 2, conduct research on people and companies before doing business with them. I cannot tell you how many times something happened, like a massive problem, and when we started digging into it, when we were actually litigating it, we found out that this person or this company had done this many times before. One example is a client of mine found out that an employee had embezzled $500,000, and he had spent all of this money on sex toys, sex workers, and pornography. So none of the money was available to get back. He admits in writing that he did this. Despite admitting it in writing and despite documenting every single time that he stole money, the cops still refused to prosecute. They said, just sue him civilly, which wasn't going to work for us because he didn't have any money. But here's the kicker. He had done it before. He had done it to his previous boss. He was already in a repayment agreement with his previous boss for the very same thing, right? He had other charges against him prior. Had my client done just a little bit of background research, a little bit of digging around, maybe even just a little bit of getting to know this guy, these things might have become apparent, or there might have just been yellow flags, like the gut feeling that something is off, something doesn't add up, right? There were other cases where I had a client who had internal workers steal employees and intellectual property to start a competing company. And when we looked into them, they had done it, these 2 gentlemen had done it multiple times. In fact, that was their MO. They went into businesses, they learned how to run the businesses, they stole all their IP, and then they left to start their own competing company. A little bit of research would have gone such a long way. Background checks are important. Absolutely. I don't think that they're sufficient. I think you should do a social media search to the extent that you can gain access to their social media. I think that you should have conversations with them if they're in an important position. This isn't just somebody that's going to be like, doing small tasks for you, or who doesn't really have the ability to hurt you. These are important people that you're doing business with that have the ability to actually cause you financial harm. Have multiple conversations with them in multiple contexts, and have one out at a bar eating and maybe drinking to see how they are in that circumstance. Introduce them to people that you know and see how they are in those circumstances. Be very slow to hire and quick to fire. I have another embezzlement story. Statistics show that embezzlers highly correlate with people that have recently filed for bankruptcy. And I had a client that hired somebody for a very high position in the company who ended up embezzling, but he had filed for bankruptcy on the day he signed his employment agreement, right? Because he knew that that's something that they would look into, because there is a very strong correlation. So if it's somebody you're doing business with, somebody you're hiring for an executive position, somebody you're co-owning a business with, anybody that's in an important position, run as many background checks as you can afford. Run a litigation search. See if they've sued or been sued, right? You want to know either one. You want to know if this is a professional. I have a client who got sued for discrimination, a completely frivolous case. Every word of it made up, not a single witness, not a single piece of evidence. And then we looked up, we did a litigation search for his name, and he had made the identical allegations against a former employer, down to like the alleged discriminatory statements were the same from this previous employer to this current employer. Had he looked into him and done the litigation search prior, he might have said, wow, this guy might actually be a professional plaintiff, right? You can see that there's a trend there, multiple lawsuits. So take your time, really get to know someone, trust your instinct. And if you don't trust yours, find somebody, maybe a business partner or even an employee or even a partner that has really good instincts, and let them meet the person. It's so much. I know that at the point that you're either hiring somebody or getting a business partner, the temptation is to sort of rush in because you're so excited about the future. And often it's under urgent circumstances where you really need to hire somebody new. And the temptation is so strong, right? To just like sign them up and see where it goes. But I could spend an hour telling you all the ways that I've seen that go wrong. So take your time, get to know them. Don't rush. Get to know them in different circumstances. Do your background checks. Okay. The third one, obviously, I'm going to sound like I'm saying something in my self-interest, but invest in legal advice where necessary. The whole point of me producing this course was to help you identify the situations in which it is necessary and in which you could really minimize your risk, and then help you identify perhaps some other situations in which it might not really be worth the money, right? So legal advice can be expensive, but cost is relative. The average cost for like a 5 to 10 page agreement from my firm, again, is going to be less than $1,000, sometimes less than $500. The cost of a dispute down the road, had they not spent money on legal advice and had they drafted their own contracts, easily could be 6 figures. So it's all relative. It's preventative medicine versus going to the doctor when you have cancer. It's not getting cancer versus hoping that the treatment works. So it's worth the money most of the time, with the exceptions that I pointed out throughout this course. And there are several exceptions in which I say, hold on to your cash, reinvest it in the business, and wait till there's a point when you have a lot more risk in that area. Use attorney-client privilege. This is number 3. So any correspondence that you send to anyone in your business on a day-to-day basis is discoverable. What this means is if there's ever litigation or there's a dispute, that somebody can literally serve discovery and get all of your emails and texts, okay? I had, when emails were a fairly new thing and I was a new lawyer, there was one case where, a massive case, this is when I was at a big law firm, where there were literally millions of pages of emails that we had to go through and look for anything relevant, and almost very little of it was relevant, but there were so many personal emails in there, just personal email after personal email after personal email. So I would say don't use your work email for personal reasons, but also the biggest thing is use your attorney. Anything even remotely sensitive, send it to your attorney and put attorney-client confidential information in the array line. This means if somebody tries to discover it, even if you're sending it to people within the company, but you include the lawyer in the conversation, most of the time, not all the time, but most of the time that's going to be deemed privileged and you'll never have to produce it. So when things start heating up and you're getting legal advice and you're maybe discussing it with like the COO, the CEO, and the lawyer, make sure you include the lawyer on all of it. If you don't include the lawyer once, it's not privileged. Include the lawyer on all of it, and then label it privileged, attorney-client privileged. And that's really going to help. Otherwise, any correspondence, even text messages between the two of you are discoverable. Be very careful. Keep contemporaneous writings. If you smell a dispute brewing, if something seems to be going wrong, somebody seems to be gearing up for a lawsuit, they're mentioning words like retaliation or whatever, and you sense that things are about to go bad, start writing everything down the day that it happens and date it. And the reason this is useful is by the time that any of these events that are happening today end up being litigated, it's going to be a year or two down the road. And your memory is going to be fallible, and they're going to know that your memory is fallible, and their memory is going to be fallible, and the judge is going to know that as well. And so what anybody testifies to at that point in time is going to be given a lot more credence if they wrote it down the same day. So-and-so said this, we had a meeting with this many people at this time, these are the subjects discussed, this is what was said, this is what was conveyed, this is what was agreed to. Put it all in writing and date it, and even sign it if you want, although that's less important than the dating of it. And then just keep that and do that throughout the whole dispute and just hang on to it for a while, because the statute of limitations might not be for a year or 2 or 3. And so don't get rid of it, store it on your computer, and just save it for the rainy day. Contemporaneous writings, huge. And then of course, obtain insurance. It's a great backstop. It is not you don't want to rely on it exclusively, because I've had to sue insurance companies who refuse to honor policies for various reasons. But I've also had insurance companies that do what they are supposed to do, and they pay up when there's a claim. And it's invaluable to have coverage. I had one client who thought he had all the coverage he needed for his business, but then he had an employee who actually killed somebody while driving. And the heir to that person ended up trying to sue the company, saying that she was driving on company time. And so my client went to see if he had the right insurance for that, and he did not, despite the fact that a lot of workers were driving. Luckily, she was actually off the clock at the time, and the woman was jaywalking, probably intoxicated, so the case didn't really go anywhere. But it was a giant wake-up call that, like, wow, he didn't have all the insurance that he needed. There's so many different types of insurance depending on what industry you're in and what circumstances apply to you. So work with a trusted insurance brokers. They're worth their weight in gold. Ask them what they recommend. Tell them all the circumstances of your business, and really try to get as much coverage as you can afford. Like I said, it's not foolproof, and it's not always going to end up making your problems go away. But it really can be a lifesaver in the event, especially if you're wrongfully sued or if you're sued for an amount of money you just don't have. Often, if the amount that they're suing for exceeds your coverage, often they'll just settle for the coverage limit instead of pursuing you individually, because it's just a lot easier to get the coverage limit from the carrier. So that's a great backstop. But yeah, use your common sense. Trust your instincts when you're doing business and something feels wrong, someone feels wrong, something feels off. Most of the time, the facts that give rise to litigation, the parties saw it coming for a while, and there were many chances to de-escalate it or prevent it, or even just make litigation less expensive by taking some of these measures. And so being a little bit proactive when it comes to staying out of court is such a great idea. You won't ever truly learn the value of those proactive measures until you find yourself in court and you see how utterly painful and often unjust it is. Our court system still is going to favor the party with the most resources. among it, and it's going to be slow, and it's just dreadfully inefficient. And, you know, I seldom see perfect outcomes come out of litigation. So it's something that should be taken seriously. But it's also something that if you get big enough, if you grow big enough, someone is going to see you as a deep pocket, and it is inevitable that you will be sued. If you are making an extraordinary amount of money, and you are, especially if you are a nationally known brand, you will get sued by some attorneys, some class action firm at some point, because it happens to everybody with deep pockets. So all of these preventative measures that you can be taking can actually help you in the long run, and they're just good practices to sort of bake into your way of operating your business. And then once you bake them in as a routine, as a procedure, then it's something that you don't have to worry about going forward. But take it seriously. If you don't believe that you should take it seriously, I would talk to anybody that's ever been sued or that's had to sue. And they'll probably tell you it was one of the worst experiences of their lives, save maybe like an IRS audit. So it's worth investing in. At my firm, I know we do even free consultations to get a general idea of what a business is, what a business needs, what their exposure is. And I even give them that advice for free. So you may be able to find an attorney that will have a consultation with you and just sort of give you some general overview, you know, in hopes that at the time that you do need an attorney, you'll come to them. But I would take those steps, and I would probably have an attorney that you keep on call, even if you don't use them much. So many of my clients use me only, you know, 4 or 5 times a year, maybe even 2 times a year when they need a new agreement, but they have me and I'm there. And I think it's a very good job to invest, or a very good idea to invest in a relationship with a business attorney. Even if you don't plan on using them a ton, and you only plan on using them at the areas which you've assessed in accordance with this course, that you've assessed to be areas of high risk, you know. But yeah, I hope you have enjoyed this course, and I hope you got a lot out of it. And if I get positive feedback and people seem to be enjoying it and it resonates, then I might do further courses, or might do more deep dives into stuff that I only covered briefly in this course. I hope you enjoyed it. Thank you.